Have you guys had any experience with insurance companies negotiating in bad faith?
Not since yesterday.
Welcome to the Case Doctors.
The client insists they felt pain right away but didn't think it was bad enough to mention at the hospital.
With John Simon and Alvin Wolff.
The fact that you went home and didn't complain of any pain at the scene, I think adds to your credibility.
The show where two of the greatest legal minds offer you advice on your cases.
You would say that this is not, a deal breaker for this case.
It makes the case harder, but it is not a deal breaker.
The Case Doctors. We'll see you now.
Welcome to the Case Doctors. I'm your host, Christine Byers of Simon Law, and I'm joined by the Case Doctors, John Simon and Alvin Wolff. Now, between them, they have more than 80 years of experience as plaintiffs' attorneys, so there really isn't a scenario they haven't already encountered on a case and figured out how to handle it or how not to handle it, as John says. Now, they're offering you the chance to tell them about the various problems or issues that are coming up in your cases and hear how they would handle it. But first, let's turn to some of the civil cases making headlines and hear what the Case Doctors have to say about them. Our first case brings us over to Florida State Court. Involves a jury that awarded a mother and daughter $17 million in damages for injuries they sustained in a 2022 apartment complex fire. Their conclusion was that they were negligent in causing their injuries from a fire that erupted after an aerosol can that was left in the oven's broiler drawer exploded while the plaintiff was cooking.
Well, I got a lot of questions for that one. I'm wondering how long they were living there and who was the renovator. I mean, it sounds like if it was aerosol can, it might have been paint. And it seems to me the company that did the renovations should be part of that, or maybe they were part of it. I don't know.
They must have had a really good lawyer on that case, because why wouldn't they ever check the broiler drawer anyway? I mean, have they ever used the oven before? I don't quite get that.
Yeah, I guess that's another thing too, is how long were they there? But I'm sure the jury, got to hear answers to those things.
If it's foreseeable, it's preventable. And they probably had a duty when they were doing whatever they did in the broiler drawer to make sure it was empty.
All right, gentlemen, and our other case takes us to Brooklyn, where a student at a private school said an insurance company is on the hook for a $9 million settlement that he entered into with the school to resolve sexual abuse claims.
So it sounds like maybe because they denied coverage, maybe it's like a 065 agreement here in Missouri, where maybe they signed a consent judgment or something like that. But usually when that happens, usually it's a judgment, not a settlement.
And it would be limited to whatever available insurance coverage there is, right?
I would think so.
Yeah, absolutely. Have you guys had any experience with insurance companies negotiating in bad faith?
Oh, yeah.
Not since yesterday.
And I think the insured, the first thing they want done is they want it to go away. So, that doesn't surprise me at all. And I see that there's hardly a case where I don't see that there's some, issue with the carrier.
But you would think in a case like this, there's going to be an exclusion in the policy, which gives the insurance company a reason to deny coverage.
It's time now to turn to our email inbox for the cases our viewers have sent in for the Case Doctors to diagnose. Hi, John and Alvin. I have a client who was rear-ended and is now claiming significant neck and back pain. The issue is that their medical records from the ER visit right after the crash state they had, quote, no acute distress and, quote, denied pain or injury. However, they started treating for pain about 2 weeks later. The defense is already hinting that this delay undermines causation. The client insists they felt pain right away but didn't think it was bad enough to mention at the hospital. Have you dealt with a situation like this before? Any thoughts on how to explain the delay without hurting credibility?
Well, I don't think not having pain immediately and complaining about it at the accident scene is that big of a deal, as long as shortly after they start undergoing treatment, and is it one visit or have they started going, and the medical records will indicate the extent of the injury more so than what they say at the scene. I mean, we talked about this I think earlier, that the adrenaline's flowing at the scene. You're thankful that you didn't get killed. I had years ago, I was rear-ended on Highway 40 here in St. Louis, and it was a pretty good clip. It was probably somebody going 30, 35 miles an hour, and I was sitting in stopped traffic. The car behind me got hit and then ran into me, and I didn't feel a thing. I just didn't feel a thing. Got up, I stood on the side of the highway. My car was damaged enough it had to be towed, and I just was not, I wasn't feeling any pain. And then fast forward later that night, I was younger at that time and in a little better shape. I was playing basketball on whatever night, Tuesday nights, and I had my bag with my basketball stuff, and I was just putting my shoes on. And all of a sudden, my back started going crazy. For the next 2 weeks, I was having horrible back pain, but I didn't feel any of it at the scene. And, I got a better understanding of how, what you're describing can happen. I just didn't feel, you felt a little uncomfortable, and I was, glad I didn't get killed, but it was something that certainly was delayed.
People don't want to go to the doctor. They've got better things to do also. And it's not an unusual situation where someone says they're not hurt at the scene. They don't go to the emergency room. They sit at home. They start to hurt. It gets worse. And finally, they go to the doctor. And it could be 2 weeks later. I think you get farther out than that, you're going to have problems. You're going to have problems anyway. But hopefully the problems won't be that bad.
And then really, what is the other side saying? What's the defense saying? That you're making it up or faking or whatever? Well, if that's what you were trying to do, you would have called an ambulance and taken a ride to the hospital, the fact that you went home and didn't complain of any pain at the scene, I think adds to your credibility.
Interesting. So you would say that this is not, a deal breaker for this case?
Not at all.
It makes the case harder, but it is not a deal breaker.
One of the things that's a real problem is, fighting the medical records is what I call it, where you can't win. It's like swimming in quicksand. And I will have clients that will just absolutely swear that I didn't say that. I didn't, say it to the doctor. And I'm like, you know what? That's not it's not going to end well for you.
I had a case where my client has had 4 hip surgeries, has a bone-on-bone knee, goes to Portugal, comes back, and the chiropractor record says she's back from Portugal where she was walking 15,000 steps a day. What do you do with that?
Yeah. I just, I don't know. It's and here's the thing. We know that there are mistakes and inaccuracies in all kinds of records, medical records, police reports. We were talking about a police report when we were off, and my only experience, in an accident where the police responded was, it was a rear ender that I had mentioned earlier, and I was waiting for the police officers to come and get a statement from me. I was aware of that. They're going to come and get a statement from me. And I actually asked them, do you need a statement or whatever? And here, a year later, somebody else had filed a suit over the accident, and I was asked to be deposed. And I was presented with a police report with my and a statement attributed to me in the report. Wow. It was accurate, but it wasn't my statement. I never spoke to the police officers. Yeah, and they wanted to clear the highway. It was obvious one car hit another car and drove it into somebody else. But fighting the medical records. What do you say?
Well, I had a situation.
Well, what did you do in your case with the woman from where was she at from?
She was from St. Louis, and I brought someone in who was with her in Portugal, saying she was in a knee brace the whole time. She couldn't walk 3 blocks versus walk 7 miles.
Well, that's a good way to do it.
But I had a situation where I got my physical this year, and I'm talking to my doctor, and he tells me something personal about him, and he puts it in my record attributable to me.
Huh.
And most of the time people don't look at their medical records, but I just happened to look at my record, and I called him up and said, hey, this was you talking, and it's in my record. So can you please take that out? And he did.
Well, that's rather nice of him. So you guys have seen firsthand that it is true when your clients say to you, I never said that.
100%.
Yeah, I had this is sort of an extreme case where I was taking the deposition of a young man who, serious case, he ran into my client's husband's vehicle. He was stopped, and he was killed in the accident, a very serious case. And I got his doctor's records, and he had a series of seizures and they were in the records. It was documented. He's talking to his doctor about the seizures he had because he quit taking the medicine so he could drink. And then finally I said, well, are you calling the doctor? Is he saying the doctor is lying about it? And I said, let's do this. Let's call him. And it was in the deposition. And I had the doctor's telephone. I had his number. And at that point, he lunged across the table and tried to my son Johnny was with me and intervened a little bit. But things got calmed down. But he was young guy, a lot bigger and stronger than me, but actually lunged across the table at me.
Wow.
You know, one thing we could do, which I haven't done with my clients yet, but you got all these organizations, medical organizations that have my chart. There's nothing that prevents the client from looking at the record. And if they note an error, send them a note saying, this is a mistake. As soon as you have an opportunity, I've done that with police reports. Where there's been mistakes in the reports, I have my client send a letter to the reviewing officer and say, this is not right. This needs to be, if the officer won't correct it, this letter needs to be appended to the report.
Yeah, and hopefully that's done, well in advance. I mean, obviously before the case gets going.
Well, if it's a police report and it's a car wreck, that's gonna happen in the first month. But I'll go through the report with the client and ask them, is this accurate? Because a lot of times they'll even have the cars going in the wrong direction.
And the other thing, too, is 9 times out of 10, what it is they're questioning about is not even, critical or highly relevant to the issue. It's just they're trying to show that it looks worse if somebody thinks they're lying about it or not being truthful about it than what's actually in the record. And again, I sure don't remember what I told my doctor this morning, when I went in for a checkup.
I mean, I was looking at some records. Clients got 10 broken bones from a car wreck. And, when she's deposed, if this case goes to suit, and she said, I have 12 broken bones, how are you going to remember if you had 10 or 12?
But, It depends. It depends on what's in the record, too. I mean, sometimes there's something in the record. And here's the thing, too. I don't care how bad it is. It's coming in, okay? Mm-hmm. It's coming in. And if you know it's coming in the case, why make it worse by belaboring it and going over it 15 times? Giving the other lawyer, a good, skilled attorney, the opportunity to make a bigger deal out of it than it is. If it's something bad, admit it and move on.
You do not want to give the other side oxygen.
Absolutely. On to our next email. Hi, John and Alvin. I'm representing a client in a civil sexual assault case, and while we have strong evidence, she is terrified of going to trial because she does not want to face the defendant in court. The idea of being cross-examined about the incident is overwhelming for her, and she's now reconsidering whether she wants to move forward. I want to support her, but I also don't want her to settle for much less than she deserves out of fear. Do you guys have any experience handling this kind of situation? Are there any courtroom accommodations or strategies you've used to make a client feel safer and more comfortable in testifying?
Wow, that's a really good question and an important issue. And I think it takes a lot of client counseling and hand-holding and explaining. But I think you just need to walk that person through exactly what's going to happen. I would take them to the courtroom. I do that with clients a lot of times where, before they testify, even at the studio, they may not testify for the third or fourth day of trial. Show them where the witness stand is, show them where they're going to be seated. But the other thing to keep in mind too is, by going after or mistreating in any way, and especially in a case like that, that is the worst thing that the defense can do in a case. And it's the most helpful thing for the plaintiff. If somebody has already gone through that, horrific, emotionally, charged, incident like that, and then they're coming into trial to testify, and the defense is going after them, or even the suggestion that they're attacking them at all, that is going to backfire big time. If you know the other attorney, that's a big help too, because you can say, I've had other cases with this attorney. They're very respectful. They're very professional.
Have you ever thought about just taking your client's deposition, videotape it, and play it to the jury?
Yeah.
I mean, does that make sense to do on something like this?
You could do that. My experience is that they're usually, if they're going to give your client a hard time, opposing counsel, defense counsel, it's usually done at a deposition and not at trial. We tried a case a year ago this month in central Illinois, and it was a rape case. And we represented a 13-year-old girl who was raped in a mental health facility for youth. And it was that exactly. It was that issue exactly. And and again, we went through everything that we'd gone through, and then she got on the stand, and my partner, Tim Cronin, was going to do her direct. And it was at a point in the trial where the jury had already heard what happened through other witnesses, and they were on the edge of their seats. The one thing I was certain about is there was no attorney on the other side was going to do anything to make her situation more uncomfortable. But she did phenomenal. I mean, she got on the stand, and Tim asked her a couple questions real quick, and then asked her about the incident. And she was 15 at the time of trial, I believe. She screamed and literally ran out of the courtroom. Tim, who had been working with her, sat in the conference room with her for about 10 or 15 minutes. She came back in, got back on that stand, and went through about a 20-minute examination. And it was the most unbelievably brave thing I have ever seen in a courtroom. It really was. The jury was locked in on everything that she had to say. But in response to your, we could have done it by video maybe, but the impact that had was, it was the high moment of the case. I think it really was. I know some attorneys that don't do any prep with their client because they want it to be a little bit more, spontaneous. Yeah. Tom Keefe, I think, told me that.
Yeah.
Tom.
Sure.
So.
I guess you've never tried a criminal case because they all want to testify.
Hey, I've missed that privilege of trying to.
They all want to tell their story.
Yeah.
Sure. So, Alvin, have you tried the taking their testimony by video, and has that worked?
The only time I've done it is when I have an elderly client, and I'm not sure if they'll be alive at the time of trial.
Wow.
So
yeah.
I'll preserve their testimony with a deposition.
Now, one thing that we do is whenever our client is being deposed by the other side, I always videotape it. There was an attorney I represented, an elderly woman who was in her late 80s, and she had been, sexually assaulted in a nursing home by someone who broke in. The attorney on the other side was over the top aggressive, and this attorney actually got into the details of the incident. And I think for the sole purpose of, intimidating her. And so I ended up trying the case about a year later. The attorney who had worked it up left our firm. And so I tried it, and I had that videotape. And at that time, she had passed away. I was representing the estate. And as a matter of fact, this was the first jury trial that I tried. It was probably 38 years ago, 37 years ago. And I was going to play the videotape deposition. And the lawyer was arguing that I wasn't allowed to play the videotape because we had a mostly female jury in St. Louis County, and that videotape pissed them off, just pissed them off.
Because it showed his behavior.
Alvin, have you had a situation with a client who was just terrified to go in, whether it was an assault or even, some clients are afraid to face the person they've been going after and fighting with for years too?
Most clients don't want to go to trial. I find that a lot of them want the lawsuit. They want the case settled. But you really have to talk to them and work them through and counsel them to let them know that if you don't have a fair offer, you have to try the case.
The thing that gets, people a little bit more motivated is, explaining that, do you really want to sweep it under the rug? Because it happened to you. Likely it happened before. It's probably going to happen again if you don't, shine the spotlight on it, and have a bigger purpose for your case. We spend so much time prepping our client for trial testimony, and we don't do it all at once. I do it in multiple sessions, like 3 or 4 sessions, and I'll do one 2 weeks out or a month out, just to see what's going on.
How long?
An hour.
An hour.
About an
That's
hour.
plenty.
Yeah, an hour. It's like having a medical procedure. Not that I really want to know about it, but if it's explained to you, you're a little less maybe you're more nervous about it. I don't know.
We're going to put you to sleep and we're going to cut your leg off.
That's right. So but what I'll do then is I'll have a second session where we get into more of the substantive issues in the case. And then the last session, what I'll usually do is have somebody else from the office do a cross-examination. Just not a direct, but do a cross-examination of what they're going to handle.
Do you ever ask your client, give me a list of 20 reasons how we could lose this case?
That's a great idea.
That's a great strategy.
That is a great idea.
Because that gets them thinking about the problems that are
Yes,
with the case.
yeah,
because
yeah.
there's never been a case that doesn't have problems. And all you need is one problem that you can't solve. and you're
That'll
cooked.
sink the ship. Yeah.
Right.
So I have a story. I had a client who was a young man, and he was a little bit angry. Like, it was in his late 20s. It was an accident where he sustained a head injury, and he would lash out a lot. And the bad news and good news was he had no memory of anything about the accident. So he really didn't need his testimony for anything. So I made the mistake of having one of the younger lawyers in the office prep him and put him on, because he didn't need to testify about anything, nor could he add or detract from anything. But he did have a head injury. That was the case. And the attorney on the other side was not nice. She wasn't very nice. And he didn't get along with her too well at the deposition, as I recall. But again, I just told him, my prep consisted of, just don't argue and be nice. Just be as pleasant and polite as you can be, because he didn't remember anything. Well, 10 minutes in, they're screaming at each other. Okay, and it culminated in him pounding on the whatever was in front of him and saying, "I deserve this." Wow, this is not. This is not going too well.
This isn't going well.
That reminds me of a story about Sam Goldblatt. And Sam was a guy who tried a case every week. And the story was the client fell down, and because they were distracted they heard a dog bark and they fell. And Sam's trying to prep them to get them ready to testify. He said, "What happened?" "I fell down." "Then what happened?" "I heard a dog bark." So sometimes preparing a client backfires.
Okay, gentlemen, that will do it for this episode of The Case Doctors. If you have a case that you would like the Case Doctors to dissect, send us an email at cases@thecasedoctors.com. And here's a QR code that will take you directly to our contact page. Once again, we will be keeping all names and cases confidential. Thank you for joining us, and we will see you next time on The Case Doctors.